Welcome, everyone. We have a lot of content today on one of my favorite topics. I will preface our conversation and presentation today with we have 45 minutes, and I could talk about nuances and complications with leave laws and how to navigate them for quite literally 4 hours. So we'll do our best. I really want to hit the highlights of the common issues that I see with respect to private schools in particular, and give you some good pointers and tips and reminders and do a refresher on some of the key requirements, particularly focusing on FMLA, the Family and Medical Leave Act, as well as New York State paid family leave. Next slide, please. So getting started with a quick refresher of the Family and Medical Leave Act, the FMLA. Remember that this is a law that provides up to 12 work weeks, 26 weeks for certain military family leave purposes, of unpaid leave in a 12-month period for qualifying conditions and reasons. This can be taken continuously, right, in one block of time, or intermittently in daily increments or even hourly increments, or as low as your increments and time tracking system will allow. I think it's also important to remember that the 12-month period can be defined by the employer, right? There are specific rules regarding a couple of options, right? A lot of employers, most employers use the rolling period, the 12-month rolling backwards, but you can use a calendar year, you can use a fiscal year, you can use some other 12-month definition as long as it's a consecutive 12-month period. If you are going to change it once you've established it, you have to provide 60-day notice. So if you're thinking about changing it, say you're on a calendar year and you want to change it to the rolling, you're going to have to do two things. One is provide a 60-day notice to all employees about that change. And two, for anyone who's currently on FMLA, you're going to have to give them the benefit of whatever is more generous as a result of that change. I think the last thing to mention on that is that should be in writing in your policies. We'll talk a little bit about policies as well. But if you don't have that in your policy, or you don't provide notice to employees about what that 12-month period is, the law says you have to provide the 12-month period that is most beneficial to the employee. So keep those things in mind as quick reminders and just a good refresher. Covered employers, for purposes of our conversation today, I think one of the mistakes I see sometimes is that we generally think about FMLA applying to private employers with 50 or more employees, or public employers, regardless of the number of employees. There's also, it clarifies that for private and public primary and secondary schools, it applies to you regardless of the number of employees. This can create a little bit of a confusing situation for some small schools. For example, as you'll see in the employee eligibility, right? Remember, employees to be eligible to take FMLA leave, they have to be employed with you for at least 12 months. They have to be employed for at least 1,250 hours during the previous 12 months preceding the leave. And they have to work at a work site with 50 or more employees within a 75-mile radius. So what has come up for me, and what doesn't make a lot of sense, but I'm telling you that this is what the guidance is clear on, is you could be a covered employer because you're a private primary or secondary school, no matter how many employees you have. But you could have, if you have fewer than 50 employees, right, none of your employees would actually ever be eligible to take this leave, right? So what does that mean for those types of situations? You still have to have a written policy. You still have to provide a notice of rights and eligibility to the employee, but you're going to have to check that box that employees are not eligible to take the leave because they don't meet that third requirement that they work at a work site with 50 or more employees. So again, even if you're a smaller private institution in school, you're still going to you could still be covered. You still will be covered by the FMLA. So that still requires you to provide some notice and have a policy in place and all that good stuff. Next slide, please. Reasons for qualifying for FMLA. As a very quick refresher, qualifying reasons for basic FMLA, right? The birth of a son or daughter, or to care for a newborn child, or the placement of a child for adoption or foster care, care for the employee's spouse, son, daughter, or parent with a serious health condition, or to recover from the employee's own serious health condition that makes that employee unable to perform the functions of their job. There's also military-related leave under the FMLA for military exigency or caretaker if a family member that qualifies under FMLA is a veteran or an active duty and is needing some care regarding their service, right? Or military exigencies, right? If someone needs to plan for certain things related to a deployment, et cetera, certain other types of, there's a nice list that the DOL provides with some examples of military exigencies. Next slide, please. So FMLA notice is required. This is something that I often see employers either forget about or not be aware of the requirements regarding what they have to do if they're a covered employer under the FMLA. So if you're covered, which you all are, if you're a private, secondary, or primary educational institution or school, you have to provide a display, a notice of the FMLA. This is an FMLA poster. Right now it's white and purple. It's available online at the Department of Labor's website. Make sure you have that as part of your workplace posters. I think it's a general good practice to include it in your handbook too, along with your FMLA policy, because along with that general notice, you have to have a clear policy in your handbook or other, written materials about leave or benefits, and it has to be provided upon hire to employees. And what you have to provide is information about FMLA as it's contained in the poster. But I think the value of having a really good FMLA policy beyond what's just in the poster is you want to provide details about your specific workplace and expectations, right? Including things like the use of PTO time, which we'll get into a little bit in a couple of slides, arrangements for continuation of benefits, if they have to remit payment, how that's going to work in order to maintain their benefits while they're on unpaid leave, or if they're on paid leave, or expectations regarding how they should be reporting those absences, all that good stuff. There's a lot of value in having a really robust and comprehensive FMLA policy, because again, this is one of those policies, it's one of those laws that is very common. It comes up particularly in schools a lot with employees who are needing to take time off for their own condition, or to bond with a new child, or to take care of family. In addition, so those notices have to be provided upon hire, and they should be in your workplaces and in your handbooks. You have to provide an eligibility notice and rights of responsibilities notice, which is one document now that the Department of Labor has put together. It's Form WH-381. That needs to be provided to employees within 5 business days of an initial request for leave, when an employer has knowledge that the employee might be needing leave, or is going to go on leave, or is on leave that may be for a qualifying, an FMLA qualifying reason. You have to provide this even if the employee does not meet the eligibility criteria for the FMLA. So anytime an employee is going on a leave of absence, I think where I see sometimes the ball is dropped or forgotten about is if someone has a workers' compensation injury and they go out on workers' comp, you should be providing the FMLA notice there as well, right? Because they're on a leave of absence for their own serious health condition, more likely than not. But if there's anything else, if you have a leave policy under your handbook, or that you provide to employees otherwise regarding bonding leave or maternity leave or whatever it is, even if it's a policy you have, that should be running concurrently, and we'll talk about that too in a little bit, with FMLA, and you should be providing that notice right at the outset. Once you go through that process, you also, and we'll talk about the forms, I think on the next slide or the slide after that, once you have the information to verify and you feel comfortable knowing that the leave that they're taking is FMLA qualifying and the employee is eligible to take the leave, the FMLA leave, you have to provide a written designation notice within 5 days of having sufficient information. So that is another form that is available to you from the Department of Labor. It's WH-382. You don't have to use these forms, I should also mention, but I strongly encourage you to use them, because there are limitations on what you can and cannot ask to employees and what information must be provided to them at these different points in time under the FMLA. So you are in a very good place if you're using the Department of Labor forms. It contains the information that they think you need and that complies with the law. So I encourage employers to use those forms. So once you have that information, you need to designate the FMLA and provide written notice of the designation to the employee. That's again important so that the employee is on notice that the FMLA is running at the same time. You're counting those absences against their FMLA allotment. Next slide, please. Here's just a quick checklist or list for you guys in terms of the certification forms. for the different things, the different qualifying reasons. For example, if an employee needs to be out for their own serious health condition, you can require them to provide medical certification. It's Form WH-380E. If they need to be out because of caring for a family member with a serious health condition, it's Form WH-380F. Again, qualifying exigency, I apologize, and military caregiver. There's a different form for current service members or veterans, right? There are forms that you can use that ask the information that you need to certify. Again, I will repeat that you don't have to ask for certification at all. The FMLA doesn't require you to ask for certification. I strongly encourage employers to do so. You also don't have to use these forms, but I strongly encourage employers to do so, again, for all the reasons I explained. It's a good starting point and a good practice. Note that for bonding leave, if an employee is taking time under the FMLA to bond with a new child, you cannot request certification under the FMLA to bond with a healthy newborn child or a child placed for adoption or foster care. Where sometimes this can be a little bit confusing is, part of, if it's the birthing parent who's taking the leave, right, you could ask for the WH-380E form to be completed as it relates to her leave or their leave related to recovery from pregnancy and childbirth, right? Or if they need to be out because of a limitation related to pregnancy or incapacity due to pregnancy, right? You can ask for the 380E. But if the leave is actually to bond with the child, you cannot ask for certification. There may be some recognition, there is recognition in the FMLA regulations regarding an employer's ability to ask for reasonable supporting documentation of a familial relationship. Again, if those situations come up, again, it's not a certification. My understanding is that you cannot, my position has been you cannot insist on certain types of documentation. But if there's a concern about whether or not the employee is taking the leave for a qualifying family member, the regulations do recognize an employer's ability to ask for some reasonable documentation. If that comes up, I encourage you to work with legal counsel to review the circumstances, the information, and figure out where you're comfortable before asking for anything in particular. Next slide, please. Okay. Other things just to mention on certification that I haven't already mentioned. You should be providing that note. If you're going to ask for certification, include it along with that written notice of the FMLA rights and responsibilities right out of the gates, right? The employee has 15 calendar days to provide the requested certification. During that period of time, they are protected under the FMLA. Once that 15 days has lapsed, they are no longer protected under the FMLA if they have not provided the requested certification. But then they will be protected as soon as they provide it. If you find yourself in that situation where you have requested certification and the employee has not provided the requested certification, I encourage employers to kindly, follow up in writing regarding status of that requested information. Again, great opportunity to partner with legal counsel to get us involved early on to help document along the way, right? Because if the employee never ends up providing the certification, there are certain things that you can do, but it's not without risk. So again, keep that on your radar. Make sure you are following up with employees who you've asked to provide the certification so that you are moving this along and this employee just isn't on a leave of absence indefinitely or for a period of time and no one has really followed up with them. If the documentation, that certification form that you receive is incomplete or insufficient, you can ask for additional information if it's necessary, right? If you do that, you have to provide written notice stating specifically what additional information is necessary in order for the documentation to be complete or sufficient, right? If certain questions on that certification form are not completed at all, or if they're contradictory, right? Those are good opportunities to push back a little bit and ask for some clarification, because once you approve it, once you designate the leave, you're stuck with those conditions on that certification form. So if it's confusing, I encourage employers to ask for the clarification. If you ask for clarification and additional information, the employee has 7 calendar days to provide that additional information. Like I mentioned, once you have that and it's complete and it's sufficient, you can't ask for more information about the FMLA leave. It's a done deal, right? That you can't follow up. There are certain permissions regarding when you can ask for new certification and those types of things, but you really can't unless you meet those criteria and you get to those points where you can ask for recertification or you need a new certification because, say, the leave that they are taking is far in excess of what the original certification said, right? Vastly different. Once you have that, unless you meet those criteria, you can't ask for more information from the employee or doctor's notes or anything like that once you've approved the FMLA. Next slide, please. Importantly, the Department of Labor issued an opinion letter a few years ago that takes the position that FMLA must be designated if an employer has sufficient information provided to them to know that the need for leave is qualifying. The opinion letter goes as far as saying that even if the employee doesn't want to designate the FMLA, maybe they want to take their PTO first and then take FMLA, that employers cannot do that. Under the opinion letter, employers have to designate the leave as soon as they know that it's qualifying. The employee does not get the option of delaying the leave. Again, if you find yourself in situations with a collective bargaining representative where perhaps that is not the case or has not been the case, work with legal counsel, because if you're going to change what you're currently doing or if it's going to be inconsistent with what you have agreed to in a collective bargaining agreement, that could create a risk under your collective bargaining agreement of a grievance or an unfair labor practice or something like that if you just unilaterally change that. But again, otherwise, if you don't have a collective bargaining representative and you are a non-union employer, then you should be designating that FMLA leave as soon as you have enough information to believe that it's qualifying under the FMLA. Next slide, please. Okay, interplay with paid time off, disability benefits, and workers' comp. FMLA does allow you to require employees to use PTO instead of just taking unpaid time off. Keep this in mind and put a pin in this because this is different from New York State paid family leave. A little spoiler alert, New York State paid family leave does not allow you to require employees to use PTO. Again, FMLA says you can do this. You don't have to do this. You don't have to require employees to use PTO while they're on an unpaid FMLA. I find in my practice that most employers do require the use of PTO unless they are receiving, here's the exception, right? You can't require it if they are also receiving short-term disability or workers' comp or PFL benefits. So if the employee is on FMLA and short-term disability or FMLA and workers' comp or FMLA and paid family leave, and they're receiving those insurance benefits from the insurance under the insurance policy, then you cannot require the use of PTO. You can allow them to use PTO to bring them to 100% of their wages, right? Because all of those are partial wage replacement benefits. Short-term disability, workers' comp, and paid family leave aren't going to bring them up to 100%, at least not necessarily. And so you can allow them to fill their cups to 100%, but you can't require them to do that if that's running concurrently. And as I mentioned before, you should be, as a best practice, running FMLA concurrently with short-term disability, workers' comp, or paid family leave, where the qualifying reason for the leave is covered by those separate leave entitlements or protections or benefits. Make sure that that's clear in your written policy. Again, another pitch for having really good leave policies. I'm a huge proponent for having really comprehensive and having a lot of value to having a really comprehensive paid family leave, FMLA, or other leave benefit policy. So make sure you have that in the written policy so it's clear to the employees that if you're taking FMLA and also is qualifying under PFL or short-term disability or workers' comp or whatever, all that's going to run concurrently and their time is going to be counted against their FMLA allotment as well. Next slide, please. Quickly on intermittent leave and reduced schedule leave, oftentimes I find that employers forget that FMLA can be taken intermittently or on a reduced schedule basis. So employees who come to you, typically it comes out in the form of an employee coming to an employer and asking for an accommodation because they can't work full-time. They can only work 4 days a week, or they can only work 20 hours a week or something like that when their schedule is usually 40 hours a week. That could qualify for, if it's for their own serious health condition, right, or disability. Think about FMLA. That could certainly qualify, and you should be providing the FMLA paperwork for that, because that's taking FMLA on a reduced schedule leave or reduced leave schedule, and it's intermittent. So as I mentioned, FMLA can be taken intermittently or on a reduced schedule when it's medically necessary. If it's taken for planned medical treatment, an employee has to take reasonable efforts to schedule the treatment so it doesn't unduly disrupt your operations. Sometimes that's easier said than done. But if you run into issues with that, again, leaves can be complicated. I encourage you to work with legal to navigate the specific issue and concerns that you're having with that specific employee. Because again, these are going to be all very individualized. Important to note that FMLA, under the FMLA, leave to bond with a new child can only be taken intermittently with the employer's approval. But the caveat is going to be, if you have PFL running at the same time, you can take PFL to bond with a new child intermittently. So it's in your best interest to run those concurrently and allow, under the FMLA, for the employee to take leave to bond with the new child intermittently as well. So that way you are counting the leave towards the FMLA allotment as well as the PFL allotment. Next slide, please. Okay, a quick overview on the 3 special rules for schools. There's a rule regarding instructional employees and intermittent reduced schedule leave. There's one about instructional employees using leave near the end of an academic term. And there's one regarding school employees returning to work after FMLA. Next slide, please. So instructional employees, kind of starting out of the gates, that the 2 rules apply to are employees whose main job is to teach and instruct students in a class, small group, or individual setting. This is going to include classroom teachers, athletic coaches, driving instructors, special education assistants, like ASL interpreters, etc. The FMLA regulations are clear that these are some examples of not instructional employees. Teachers, assistants, or aides who do not have as their main job actual teaching or instructing, as well as counselors, psychologists, curriculum specialists, cafeteria workers, maintenance workers, and bus drivers. So keep that in mind. Again, sometimes these are some examples that are provided. If you're not sure if an employee is instructional or not, again, it's important to take an individualized look at what the individual's main job function is. And if they're teaching or instructing students, then there might be a good argument that they are instructional. Next slide, please. So the general rule, right? So this is not the school rule, but the general rule is that if an employee needs intermittent or reduced schedule FMLA leave, that's foreseeable based on planned medical treatment or based on an agreement between the school and the employee for bonding with the new child. The school may temporarily transfer that employee to a different job that the employee is qualified for to better accommodate that schedule and that need for recurring leave. The temporary reassignment has to be at least the same pay and benefits, and you can't transfer an employee to discourage them from using the FMLA or creating a hardship for the employee, right? The special school rule is a little different. So if an instructional employee uses intermittent or reduced schedule leave that is foreseeable based on planned medical treatments, and it's needed for 20% or more of their working days during the period that they need leave, then the school can grant the intermittent leave request or provide the employee with a choice of transferring to an alternative position or taking FMLA for a particular duration, like a set of time, a block leave of time. But it's ultimately up to the employee to choose which of those options they want if the school decides to apply the rule. You don't have to apply the rule. Again, it's a permission, it's a permissible option, but you don't have to. You could default to the general rule if you wanted to. Note that you have to reinstate the employee to their original position when the leave is over. They have those protections to reinstatement to their original position once their FMLA leave has concluded. Next slide, please. The rule regarding instructional employees using leave near the end of an academic term. So this can become a little bit complicated, and sometimes you have to map it out because it's going to depend on when the leave begins. So if the leave begins more than 5 weeks before the end of a term, an instructional employee's leave can be extended to the end of the term, but only if the leave is going to last at least 3 weeks. and the employee would return to work during that 3-week period before the end of the term. Again, I think the intention is to minimize disruption to students where a teacher might come back to work and there's only a couple days left of school, right, at the end of the term. It might be less disruptive to just have the substitute continue on and have the employee out through the end of the term, right? That's consistency and continuity for the students, as well as the teacher in some regard, right? If leave begins during the 5-week period before the end of a term, an instructional employee's leave may be extended through the end of the term, but only if the leave is for the birth or placement of a child or the care of a family member or covered service member, and it's going to last more than 2 weeks, and the employee would be returning to work during that 2-week period before the end of the term. And then the last one is if the leave begins during the 3-week period before the end of the term, an instructional employee's leave can be extended through the end of the term, but only if the leave is for the birth or placement of a child or the care of a family member or covered service member, and the leave is going to last more than 5 working days. So this is just something to keep in mind. Don't feel bad if you have to frequently look at it if it comes up, because it doesn't come up very often, but keep the red flag in mind. If an instructional employee is going to take leave towards the end of the semester, then you might want to look at this rule and refresh your memory or take a look to see if you want to apply it or not. Again, these are permissible rules, right? You don't have to do this. You don't have to extend their leave through the end of the term. If you want them to come back and there's only 2 weeks left of school and the rule applies, you can certainly do that. There's nothing that says that they have to be out. It is just an option that is presented to schools, again, I think with the intention of trying to minimize disruption to the educational environment for students. Next slide, please. Breaks between semesters. So when a school employee uses leave for a period that ends with the school year and begins the next semester, maybe they're out, at the end of the school year, and they're still going to be out in September once school starts up again. That is going to be considered a consecutive leave of absence, not an intermittent leave of absence, even if there's that summer break in between. Another mention about breaks between semesters, the period during summer vacation when the employee would not have been required to report for duty is not going to be considered leave time, and it should not be counted against the employee's FMLA entitlement or allotment. So that means, right, unless the employee is a 12-month employee and they should have been reporting to work in the summer, that time should not be counted, right? So for your 10-month employees, if you will, that are off during the summer break, even if they need FMLA leave from May or June through September, you're only counting the days that they would actually be required to report to work for the most part. That's an abbreviated version, but that's the way to think about it. During that summer break, employees have to be provided with the benefits that they would have normally received if they had been working during, at the end of the school year, just like any other employee, right? So they shouldn't be treated differently just because they're on FMLA leave necessarily, and they're taking that, they're not working, or their leave extends from the end of the school year to the beginning of the next school year. Next slide, please. Okay. One other thing to mention about that instructional employee rule using leave near the end of the school year. The law is also clear that if a state law prohibits employers from requiring leave beyond an actual period of pregnancy disability, then you can't apply that rule. You can't require the employee to remain on leave until the end of the academic term. You have to bring them back even if they only have a couple of days left in the term. Right, so that's going to be a consideration under the New York State human rights law. It is clear we have a law here in New York that says an employer cannot compel an employee who's pregnant to take a leave of absence unless the employee is prevented by such pregnancy from performing the activities involved in the job or occupation in a reasonable manner. So if the employee is able to come back, you have to let them come back. If the employee is out for an extended leave through the end of the term, that leave cannot also be counted against the FMLA leave as well. So if you apply the rule for near end of term for the instructional employees, even if you choose to apply it, right, it applies, you choose to apply the rule and you have them out through the end of the year or the academic term, you can't count that extra 2 weeks or whatever it is right at the end of the day towards their FMLA allotment, because you're forcing them to take that leave. And you can't count it against them for purposes of attendance under your policies. So that's just something else to keep in mind if that instructional employee using leave near the end of the academic term rule applies. Next slide, please. Okay, just a couple of definitions. The academic term is going to be that school semester. And for purposes of the FMLA, a school cannot have more than 2 academic terms each year. So if you are on trimesters, it doesn't matter. For purposes of the FMLA, the school, they don't recognize that. Okay, lastly, under the FMLA, before we shift to PFL, quickly, this rule under the FMLA applies to all school employees when they're returning to work after FMLA. So the FMLA generally requires employees to be restored to their original job, as I mentioned, or equivalent job with equal pay and benefits and terms and conditions of employment upon returning to work from their FMLA leave. The recognition that restoration of employees of public schools to their original job or equivalent job may be based on board or school policies, practices, and collective bargaining agreements, right? They can still be restored to the same or equivalent position, but if you have a different policy or rule that applies, then the FMLA recognizes you might still be able to apply that rule. For example, if they have to reapply for the position or take some sort of action to reapply for the position. But in order for that rule to apply, again, it's going to have to be really specific. It has to be in writing. It has to be made known to the employee prior to taking leave. You have to clearly explain the employee's rights to return and restoration of their position upon returning from their leave. And you have to provide substantially the same protections as the FMLA. To be honest, I don't see this much in practice, but it is there. So if it's something that you think may apply to your school or to your operations and policies, it's worth exploring and digging in deeper to make sure you're on the same page and you're complying with the FMLA requirements and applying this rule appropriately. Next slide, please. So quickly, I know we spoke a lot about FMLA. I think the FMLA has a lot of more, there are more recognitions for special rules that apply to schools. And so in this last 15 minutes or so, we'll talk about paid family leave. There just isn't as much, there aren't the same types of recognitions necessarily as the FMLA. But for purposes of our conversation, right, I want to talk about paid family leave. I want to talk about some of the exceptions regarding private schools there are some things that you should be aware of, as well as the interplay and some of the issues that I see when employers like private schools have FMLA and PFL happening at the same time. So quick refresher, paid family leave is a wage replacement benefit. It also provides up to 12 weeks of job protected leave in a 52-week period. Again, employees can take this continuously in a block of time or intermittently. Key difference with paid family leave versus FMLA, under paid family leave, they have to take intermittent leave in full day increments. You cannot have partial day increments. When you have FMLA running concurrently with paid family leave, what I have encouraged employers to do is you run it as FMLA leave, and then if it's less than full day increments, right? Once that time ends up adding together to be one full day, then you count it against their PFL and you give them their PFL. So this applies to private employers like yourselves. There are a couple of exceptions for who's not covered that we'll talk about in just a second. But the qualifying reasons for PFL are bonding with a new child following birth, adoption, foster care, or placement for foster care, or caring for a family member with a serious health condition. The types of family members or qualifying family members under PFL is broader than FMLA. Under PFL, this includes a spouse or a domestic partner, a child, a parent, a grandparent, a grandchild, and a sibling. It also is available for preparing for military family support. That's going to be similar to the military exigency leave. Important to remember that paid family leave is not available for the employee's own serious health condition. If the employee cannot work because they are having some sort of medical issue themselves, you would apply short-term disability, right? Not paid family leave. So that's going to be different from FMLA as well. Next slide, please. Employee eligibility. So in order for an employee to be eligible, so this is a employee fully funded benefit, meaning that the funding for this insurance comes from employees directly and exclusively, unless you agree to fund it otherwise. But you don't have to. So deductions are taken from employees' paychecks starting on the first day of employment. And that's what they contribute from day one. They are not eligible to take PFL until they meet certain criteria. So if they work 20 hours or more per week, then they become eligible after 26 consecutive weeks of work. If they work less than 20 hours per week, they become eligible after 175 days of work. And again, that's to take PFL, but you will be taking deductions from their payroll towards PFL insurance since the beginning of their employment, unless they meet one of the waiver criteria, which again is very narrow. In short, sum and substance, an employee is only going to be eligible for a waiver if they are not going to meet any of these eligibility criteria. But and you have to have them sign off. Next slide, please. As I mentioned, PFL has to be taken in full day increments. This is a partial wage replacement benefits. It's 67% of the average weekly wage of that employee up to that state cap that changes every single year. I mentioned earlier, another key difference is that under New York State paid family leave, if someone's taking PFL, you cannot require them to use paid time off concurrently as they're receiving PFL benefits. You have a couple of options. You can allow them to supplement to bring them up to 100%. You can allow them to substitute, right, in full day increments, or you don't have to allow either of those. And if an employee takes PFL, they just get their PFL insurance replacement, wage replacement benefit directly from the insurance, the 67% up to that cap, and that's it. They're not supplementing, they're not getting topped off to 100% through their paid time off benefits. What's kind of nice for you guys for PFL is that the claims are processed through the insurance carrier. So your job is to provide them with information. You should have a written policy regarding paid family leave and all those details of use of PTO and how employees should be submitting requests for PFL and expectations and all that good stuff should be in your PFL policy. But ultimately, you are not making the decision about PFL. You are providing them with the paperwork. They're filing the claim with your insurance carrier, and your insurance carrier is the one that's ultimately approving or denying the claim. I've mentioned before that this should be running concurrently with FMLA. Make sure both PFL and FMLA policy have clear language regarding that the time is going to be run concurrently. You should also notify employees at the outset of the leave, just so that it's clear that the time is going to be counted against both. Again, if it qualifies under both. And as I mentioned before, if you have a partial day of FMLA time that also qualifies for PFL, then you would still have them file the PFL claim, and you are going to, once it adds up to one full day, then you count it against their PFL allotment. Next slide, please. Okay, here's just another slide regarding the interplay with PTO. The only other thing I want to mention regarding this is that, sometimes employers will ask me, what's the difference between supplementing and substitution? And in some, supplementing is going to be where you top them off, right? They get the 67%. So you are giving them and issuing a check for 33% of their wages for that day, right? That they were out on PFL. And you're kind of topping them off in that way. If you do substitution, what generally employers will do, and I encourage you to work with your insurance carriers on this, is the employer will pay the employee 100% of the wages, and then you as the employer will get reimbursed from the insurance. So the employee's not going to get a check from the insurance in the substitution example or election. They will get paid by you, and then you will get reimbursed of that. You'll get the 67% check from the insurance. So I have found in my practice that most employers do it that way if they feel comfortable. and have a good process and understanding with the insurance company of how that happens and works out. But I would encourage you to work with your insurance company to understand what that process looks like, how it might be different, so that everyone's on the same page. And as I mentioned, you could also not allow employees to substitute or supplement PTO. They just get their 67% check from the insurance company, and that's it. Some employers have taken that option because it's administratively burdensome to do either the substitution or the supplementation election. So I do have clients who have made that election, and they say, no, you file your claim with file your claim with the insurance, and then you just get what the insurance is providing to you. Next slide, please. Special PFL rules for private schools. So you're a private school, you're a private employer, you have to have PFL insurance and disability insurance. However, you do not have to have coverage for ministers, priests, rabbis, members of clergy, etc. You don't have to have coverage for individuals that volunteer their services for your nonprofit organization and they receive no compensation. You don't have to have coverage for executive officers of your institution, and you don't have to have persons engaged in a professional or teaching capacity for your institution either. Professional is going to be the same definition as the professional exemption under the wage and hour law. So you have to have, the main point is you have to have a disability policy and PFL policy for all of your other employees, but you don't have to provide coverage to these specific classifications of employees. You can voluntarily opt in to provide disability and PFL benefits. There is a very special process, and it can be a little bit complicated regarding how to go about doing that. If you have not, if you have your policies, but you haven't opted in, and you want to opt in, that can be further complicated by the fact that you have a unionized work setting. But again, encourage you to work with legal if you have questions about opting in or what your obligations are. But in my experience, most establishments will just have the basic DVL and PFL policies, cover everyone else, and do not cover the individuals that don't have to be covered. Next slide, please. Don't forget, leave can be an accommodation. Leave can be an accommodation. So that's the last thing I'll mention during this session is once someone has exhausted paid family leave or FMLA, they often say, can we, this person still can't come back to work. What do we do, right? If the employee needs an accommodation for pregnancy or disability, childbirth, pregnancy, et cetera, and related medical conditions, then they may still be entitled to more leave time as an accommodation under the federal and state laws. So don't just make a judgment call about they've exhausted their FMLA or their PFL, and so they can't come back to work. We're just going to terminate them, because it's typically not that simple or easy. There are other considerations and risks if you were just to do that. So I just put that in there as a reminder of leave as an accommodation. One other thing I wanted to go back to that I should have mentioned earlier in the presentation regarding FMLA eligibility and the eligibility requirement to work 1,250 hours in the year preceding the leave. There is also a special recognition in the regulations that teachers will be essentially presumed to meet that 1,250 hours because they're not just working the contractual workday. A lot of teachers are doing stuff outside of the contractual workday, whether it's preparing lesson plans, calling parents, communicating with parents, meeting with parents, holding other sorts of meetings, engaging in other sort of preparation. And so in those cases, if you have a teacher who needs leave and you're looking at FMLA, you should also be mindful of that presumption, because then the burden is going to be on you as the school and the employer to prove that they did not work the 1,250 hours to meet that eligibility criteria for FMLA. And I think on that note, it's incredibly important to keep good documentation regarding attendance and time actually worked, even for your exempt employees, for this very reason, right? You're going to want to be able to see specifically and be able to prove that the person did not work that time if that's the case. Again, case-by-case evaluations and considerations for all of these things. If you have questions, I encourage you to team up with your legal counsel to work through them with you, because these can get complicated and they can get confusing, but we're certainly here to help.